course, people will argue that she shouldn't have to quit her job because of her religious beliefs, but again, think of the burden. The difference is quitting a job versus being able to marry the love of your life, or be listed on the love of your life's death certificate so that you can tell the coroner what to do with his remains, or be listed on the birth certificate of a child that you consider your own but is adopted. These are not equal, and I'm mad. Hello. I'm currently drinking what my friends and I like to call a danger beverage. It is 4:19 in the afternoon, and I'm drinking coffee, so just live life on the edge around here. Will she sleep tonight? Only time will tell. My name's Leja, I'm a real-life lawyer, and I'm on a mission to demystify the law and how it affects your everyday life. Today I want to talk to you about the marriage equality case, Obergefell v. Hodges. This is the case that ruled that bans on same-sex marriage were unconstitutional in 2015. It's a case that changed a lot of people's lives for the better, and mildly inconvenienced a few bigots who, for some reason, continue to squabble about it. Why am I talking about it now? Because it's one of the many rights that are currently in jeopardy. On October 5th, Justices Thomas and Alito of the Supreme Court issued a statement basically reasserting that they hate Obergefell and inviting people to bring cases so that they could one day overturn it. But more on that later, let's just get into the case. Before I get started, I would like to offer the following disclaimer, and that is that I'm a lawyer, but I am not your lawyer. Nothing that I say should be construed as legal advice, and you should always seek the advice of a licensed attorney if you have any legal questions. As always, I will also be getting ready because that seems to make these things more interesting, and I'm trying to draw the people in so we can learn a little bit more about constitutional law while I put on highlighter. Let's go. So the background on this case is a mess. Like, there are just so many actors and so many people involved in this case that it's hard to even know where to start. But let's start high level. Oh God. Basically what happened is that there were 6 cases in 6 separate district courts which all decided the issue of whether state bans on same-sex marriage were unconstitutional. In these 6 cases, the plaintiffs, so the gay couples or their representatives, etc., won. So all of the cases were appealed up to the 6th Circuit Court of Appeals. You may or may not know that our federal legal system is divided up into a bunch of district courts all over the country that are within circuits based on location. So like the 1st Circuit is in the Northeast, the 7th and the 8th are in the Midwest, and then confusingly, the 9th is in California and the 11th is in Florida. But anyway, there are 11 circuits, and each circuit has its own appellate court. Plus, DC has its own circuit because it's fancy, and there's the federal circuit, which decides very specific issues like patent cases, for example. So each circuit has a bunch of district courts, and then there's one appellate court in each circuit. Then from the appellate court, you appeal it up to the Supreme Court typically. The problem with this is that you have so many cases coming from the district courts and then up to the appeals courts, it would be impossible for the Supreme Court to then hear every single case that is appealed to it. So a lot of times the cases that take priority are the ones where there's a split in the circuits, meaning that circuits have ruled differently on a similar issue, so SCOTUS takes it up so that they can make a definitive decision so that the courts aren't applying the laws differently all across the United States. And that's exactly what happened here. Because in 2014, there was a ton of action around the right to marry across the United States, and 4 circuits ruled in favor of same-sex marriage, meaning that it was unconstitutional to ban same-sex marriage. Those were the 4th, 7th, 9th, and 10th circuits. So then you have the 6th Circuit with all of these cases being appealed up to the circuit court from Michigan, Ohio, Kentucky, and Tennessee. And because all of these cases had common legal questions, they were all smushed together into one common case at the 6th Circuit level. And the 6th Circuit ultimately ruled against them. The circuit cited this case called Baker v. Nelson, which wildly is this Minnesota State Supreme Court case from 1971 that upheld a ban on same-sex marriage. And the Supreme Court didn't actually make a ruling on it, but because of some procedural technicality, it technically still counted as precedent that this 6th Circuit Court, a bunch of states away and 40 years later, could cite to as reasoning for why it was upholding this ban on same-sex marriage. None of the 4 other circuits that found banning same-sex marriage unconstitutional had an issue with this case or cited this case, I don't think, but for whatever reason the 6th Circuit used it. Anyway, so you have these 4 circuits that are like, same-sex marriage, totally cool. Then the 6th Circuit comes along and is like, nah, not gonna happen. So then SCOTUS took up the issue because of this split in the circuits. All right, so that's the general background, but the namesake case is Obergefell v. Kasich, and it's out of Ohio. The reason that the original name Obergefell v. Kasich is different from the final name Obergefell v. Hodges is because when you're suing because you believe that your constitutional rights are being violated, you can't actually sue the government directly, so you have to sue the representative in charge of enforcing the laws. And as you know, government officials change a lot and move around, so the names of these cases over the course of the span of a case, which can take 2 years, 3 years, however many years, are going to change based on who the representative is at the time that they need to be suing. So Kasich was the governor of Ohio at the time. Anyway, So the story goes, Jim Obergefell and John Arthur were a gay couple who decided to go to Maryland to get married, because this was back when there were some states that allowed gay marriage and some that didn't. John was sick with ALS, which is a terminal illness, so they flew to Maryland, and at the time of their marriage, he was so sick that he couldn't really move very well, so they actually just got married on the tarmac before heading back to Ohio. The problem, though, was that at the time, gay marriage was illegal in Ohio, but also Ohio didn't recognize same-sex marriages that were performed legally in other states, which is wild because at the time, Ohio did recognize marriages between cousins, between minors, even if they were illegal in the state of Ohio, but apparently the gays were the gross ones. Anyway, so Jim and John sued. Meanwhile, there's this other gay couple named David Michener and William Herbert Ives. They were married in Delaware, which recognized same-sex marriage, and they had 3 adoptive children. William died unexpectedly in Cincinnati, Ohio, which that's bad luck. And what's worse is the director of the funeral home couldn't do anything with his remains because David wasn't listed on his death certificate as a surviving spouse, so he couldn't tell the funeral director William's last wishes, which were to be cremated. Yikes. And so David, because he had the same claim basically as Jim Obergefell, which was that it was unconstitutional for Ohio to not recognize his marriage, he joined in as a plaintiff with Obergefell's case. Then in October of 2013, Jim's husband John died of ALS. And what's the most messed up is that the state, literally within days of his death, moved to dismiss the case as moot because he was dead. What is with people? Luckily, the judge denied that motion and ultimately ruled in favor of Obergefell, saying that Ohio's law against recognizing same-sex marriages from out of state was, in short, pretty heinous. So that's the namesake case. I'm not going to get into the other 5 cases because honestly, there are so many plaintiffs in every single one of the case, I just wouldn't do it justice. I will note, however, that one of the couples in one of the cases was named Brittany and Brittany, which are objectively the worst ways to spell the name Brittany, but I wish them all the best. Anyway, so like I said, the cases all got smushed together because they all had similar questions of law, and they all went before the 6th Circuit Court of Appeals, and a panel of 3 judges ruled against the plaintiffs, 2-1. Can we just take a moment, though, to take a look at this judge that ruled against them, though? Judge Sutton. He said, not one of the plaintiffs' theories made the case for constitutionalizing the definition of marriage and for removing the issue from the place it has always been since the founding in the hands of state voters. Which is a common argument all the time, that the states should be the ones to decide, but it kind of overlooks the fact that the Supreme Court and other courts have regularly ruled against state laws that were discriminatory because we gotta check them when they're discriminating against people. I don't know. It makes sense in my head, but what do I know? So this case was appealed to the Supreme Court, and eventually the Supreme Court agreed to hear it to settle the circuit split. And the Supreme Court asked both sides to write briefs answering 2 questions. 1, whether the 14th Amendment required that a state license marriages between same-sex couples, or put another way, whether it was unconstitutional to deny marriage licenses to same-sex couples. And number 2, whether the 14th Amendment required that states recognize out-of-state same-sex marriages. A historic number of amicus briefs were filed, 148, including one on behalf of 379 businesses, basically just making the argument of why same-sex marriage was good for business. And that's a lot. I explained amicus briefs in a different video. I'll link it right here. But basically, amicus means friend of the court. It's where non-parties to the case can submit briefs to the court arguing for one side or the other, and then the court has the choice whether or not they're going to take those briefs into consideration. Oral arguments were heard in April, and then on June 26th, 2015, the court made a ruling, and they ruled in favor of the plaintiffs. The court found that the 14th Amendment required states to issue marriage licenses to same-sex couples and required states to recognize marriages from other states. The opinion was written by Justice Kennedy. Kennedy was known for often being the deciding vote on issues because he wasn't one side or the other all the time, though he was a Reagan appointee, and he did do us dirty because he retired in 2018 during the Trump presidency at the age of 82. Like, he had 8 full years during the Obama presidency when he could have retired, but he waited till 2018, which then gave Trump the ability to nominate a second Supreme Court justice, the first being Gorsuch. So he nominates Kavanaugh. Interestingly, both Gorsuch and Kavanaugh were clerks for Justice Kennedy at one point in time. The elites like to keep a tight circle, I guess. Let me just read you the opening paragraph of this decision, though, because it's kind of weird. From their beginning to their most recent page, the annals of human history reveal the transcendent importance of marriage. The lifelong union of a man and a woman always has promised nobility and dignity to all persons, without regard to their situation in life. Marriage is sacred to those who live by their religions, and offers unique fulfillment to those who find meaning in the secular realm. Its dynamic allows two people to find a life that could not be found alone, for a marriage becomes greater than just the two persons. Rising from the most basic human needs, marriage is essential to our most profound hopes and aspirations. Like, yeah, this guy was 80. You could tell when he wrote that. Woof. But then he goes on to say some nice things about how same-sex couples weren't trying to denigrate the institution of marriage by trying to get married. They were actually trying to become bound by it because they valued the institution so much. He also talks about how marriage has evolved over time from being a political or monetary contract between parents to being a voluntary contract between spouses, so it can evolve again without degrading the institution of marriage. He also cites the changing attitudes towards same-sex marriage and homosexuality. He talks about how homosexuality was seen as a mental illness up until the 1970s. He also notes a few important cases, including Bowers v. Hardwick, which was a SCOTUS case from 1986, which upheld a Georgia law that criminalized homosexual acts. 1986, not that long ago. And then Lawrence v. Texas, which is a 2003 Supreme Court case, which finally held that criminalizing homosexual acts was unconstitutional. 2003, like within this century, very few years ago, homosexual acts could be criminalized. So as I said, the legal arguments in the case all rest on the 14th Amendment, specifically the Due Process Clause and the Equal Protection Clause. It's a really long amendment, so I'm not going to read the whole thing to you, but let's just take a look at the Due Process and Equal Protection Clauses. They are in Section 1 of the amendment, and they say, "No state shall deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." So I've talked about the 5th Amendment before in my Korematsu video, and if you watch that video, which you should, you might be saying, hey, wait, isn't the 5th Amendment where the Due Process Clause is? Good eye. Both amendments have a due process clause. The difference basically is that the 5th Amendment applies to the federal government, whereas the 14th Amendment applies to state governments, meaning if there's a law that you're saying is unconstitutional and it's a federal law, you sue saying that your 5th Amendment rights to due process are being violated. And if there's a law that is unconstitutional that's a state law, you sue under the 14th Amendment saying that your due process rights under that amendment are being violated. Laws. Cool. And just as a note, there is no equal protection clause in the 5th Amendment, so you might be wondering, does equal protection extend to federal laws? And the answer is yes, it has been interpreted to include substantive due process, meaning that the substance of the law cannot unduly deprive people of their life, liberty, or property. I talk a little bit more about that in that Korematsu video. So anyway, this case about the 14th Amendment. And there's a lot of precedent in the 14th Amendment indicating that the word liberty in that due process clause extends to private matters like contraception, procreation, and yes, even marriage. In Loving versus Virginia, the court ruled that bans on interracial marriage were unconstitutional. So it's not like it was this far stretch to say that liberty, as embodied in the Due Process Clause, extends to marriage, including same-sex marriage. However, Loving was decided in 1967, so why did it take until 2015 for that liberty idea to extend to same-sex marriage? I don't really know the answer to that, but I think it's because of just deeply entrenched homophobia. In order for a case to get to the Supreme Court, there has to be a general understanding by the people that the rights that are being violated should be protected under the 14th Amendment. I'm not saying that there weren't people for 50 years screaming about how gay marriage should be constitutional and protected under the Due Process Clause. I'm just saying generally as a society, we hadn't gotten that far. We hadn't realized that interracial marriage and same-sex marriage should equally be protected. Then there wasn't enough momentum to get this kind of case up to the Supreme Court because homophobia. Again, you'll remember that homosexual acts could be criminalized until 2003. So as far as the Equal Protection Clause goes, the court points to a number of cases, including Loving versus Virginia again, to show that equality under the laws is inherent within that word liberty in the Due Process Clause. So to have liberty, you have to have equal treatment of the people. If you don't treat people equally, then they don't have liberty the way that everyone else does. So because the laws in question burden the right to marry, which we've determined is a fundamental right under the Due Process Clause, and it burdens same-sex couples differently than everyone else, then it goes against the Equal Protection Clause and is thus unconstitutional. There's also a great argument against finding that same-sex marriage infringes on a person's First Amendment right to practice religion freely. When you think about the idea of burden and what kind of burden is happening. Because yes, being able to practice your own religion and have sincerely held religious beliefs is protected under the Constitution, but the right of same-sex couples to marry is not burdening your right to freely practice your own religion. And that brings us to today. So the statement that Justices Thomas and Alito made were regarding a new case called Davis v. Ermold. That case came out of Kentucky, and it involves a woman named Kim Davis, who was a county clerk in Kentucky responsible for issuing marriage licenses, and she denied a couple gay couples a marriage license, and so they sued because Obergefell already happened and what, you know? But she's claiming that this burdens her sincerely held religious beliefs. And that's not an unfounded argument, but let's talk about burden here. So one side is burdening the fundamental right of people to marry, and if they can't marry, there's no other options. They're gay. They're gonna wanna be gay married together. That's just how it works. If they can't do that, then they have no other option. The other is burdening the sincerely held religious beliefs of a person who made the choice to get a job that would require them to issue marriage licenses to gay people. Here's the fun thing about a job, you can quit it. And of course people will argue that she shouldn't have to quit her job because of her religious beliefs, but again, think of the burden. The difference is quitting a job versus being able to marry the love of your life, or be listed on the love of your life's death certificate so that you can tell the coroner what to do with his remains, or be listed on the birth certificate of a child that you consider your own but is adopted. These are not equal, and I'm mad. So weirdly, the court actually declined to hear Davis v. Ermold, but in declining to hear it, Justices Thomas and Alito issued this statement basically saying, for technical procedural reasons, this is not the right case to be heard by the Supreme Court, but basically inviting people to bring a case that will be able to get up to the Supreme Court so that they can eventually overturn Obergefell. Which is scary and a very real possibility considering the fact that Obergefell v. Hodges was a split decision. There are 9 justices on the Supreme Court, and this decision was 5-4 in favor of Obergefell. So that's a narrow margin. 2 of the 5 justices that ruled in favor of Obergefell are no longer with us. Kennedy is retired, and, well, RBG. This on top of the fact that the confirmation of Amy Coney Barrett seems pretty much solidified if it's not already a reality whenever you're watching this video. And that's why the case of Obergefell v. Hodges still matters. I hope you found this helpful. If you found it informational or entertaining, please give it a thumbs up. Comment below if you have any other cases you'd like me to talk about, and subscribe if you want to hear more from me. Thanks so much for watching. Have a good day. Goodbye!